Good afternoon, everyone, and welcome to the Court of Appeals. Your panel today consists of me, Judge Donna Stroud. To my right, we have Judge Allegra Collins. To my left, Judge Toby Hampson. We have one case for argument today, and I think y'all had some documents and things, and you got all your technical things straight, I believe. And this is weird, okay, because like our video is on our screen up here, and this has never happened before. So we're watching ourselves, and it's super weird. So if you see us like looking at this, I'm hoping it doesn't do that the whole time. But anyway, let's see. We've got a lot of our summer interns and externs are with us, as y'all might have noticed today for our argument, and we're very happy that we have them here to have this experience and learn a little bit from y'all. So I'm sure you'll teach them. And have you already arranged your time for rebuttal?
Yes.
Okay. All right. We've got that set. All right. Then we can proceed.
Good afternoon. My name is Craig Justice. I'm with the Buncombe County Bar. I'm here on behalf of the petitioner plaintiff Grey Outdoor. This appeal is from the trial court's summary judgment ruling denying my client damages, attorney's fees, and costs. What is not before you is the trial court's ruling in our favor, where the trial court ruled that the controlling statute dealing with the standards for issuance of the permit, state permit in this case, was plain, and that the department had erred in failing to issue those permits. So the trial court's ruling in our favor is not before you because the department did not appeal. I just want to touch on some of the facts. My client, Grey Outdoor, applied for 4 permits to erect 4 billboards on a tract of land in the town of Newport, down east in Carteret County. The tract in question was on, or is on, Highway 70. It's a commercial corridor with commercially zoned or commercially used activities. It is, importantly, not a designated scenic byway or scenic highway, which is an available tool of the department. If they find that a corridor is sufficiently pretty enough, they can go through a process to designate a corridor as scenic byway or scenic highway. That was not done here. The tract in question does border the boundary of the Croatan National Forest. In early summer of 2023, my client, after applying for the 4 permits, received an email from the department official, and this is found on pages 114 and 115 of the record, where Mr. Parker, who is an agent of the department, noted that there was a concern about the property's proximity to the Croatan National Forest, and Mr. Parker was kind enough to attach a statute that he was relying upon in justifying his concern. The statute in question, which is the controlling statute, is GS 136-129.2, which is hopefully on your screen instead of your faces.
Yes. Thank you.
So oftentimes we don't have the luxury when the General Assembly writes law that there's some vagaries and ambiguities that might exist. Even department regulations, when they write regulations, there could be some vagaries and ambiguities that exist. We have contended, and the trial court agreed, that this law is not an ambiguous law. It is plain. And as you know, the General Assembly gets involved in making sausage of law, where they listen to a lot of constituents, a lot of different public interests, a lot of competing interests, and ultimately they, as the legislative branch, the elected officials, decides what's the public policy for the state. And so they have to balance all these competing interests when they ultimately come out with law. And here is a prime example where the General Assembly has said there are certain places or locations in the state where we're going to say a billboard cannot be too close to. And in this case, this statute says there are essentially 4 places in subsection 1B where there has to be a 1,200-foot separation. It lists their national a state park, national park, state or national wildlife refuge, or designated wild and scenic river. Now, it's important to note that, of course, the General Assembly went ahead and described all these competing interests in the purpose section above, when it ultimately said that in weighing all these interests, which includes the ability of an outdoor advertiser to have a sign, ultimately, after weighing these interests, the substantive standards followed that sets what the law is. And 1B, it very clearly sets the standard for essentially 4 known places. So Mr. Parker notified our folks that the Croatan National Forest was going to be a problem and cited the statute. Our folks immediately responded. This is on page 114 of the record, with a very nice email that said, Mr. Parker, a national forest is not on the list. Please see all of these links that are maintained by governmental agencies. So this is not some blogger out there. These are the governmental links describing where all the locations that are listed in that controlling statute, where they are, and that the Croatan National Forest is clearly not on those lists. So what we've come to find out is that ultimately the department still hunkered down with saying, well, we think the National Forest is eligible under that statute. So they denied the permits. We appealed it to the Secretary of Transportation. He ultimately issued a ruling. When they initially denied the permits through discovery, we tried to get a sense of what did they do to investigate this issue of, does the Croatan National Forest fall within the list of things listed in the statute?
Can I just,
Yes, ma'am.
is the issue, or at least was the issue below, whether it was a national park, whether the National Forest was a national park? Is that the very...
I'm glad you asked that. If you asked, we had 3 witnesses we deposed, and they all came up with different answers, which underscores the arbitrariness of their decision-making. The first witness, Robert Taylor, who's the district engineer, who was assigned by statute and regulations to make the call, he says, I had nothing to do with it. And he deferred to a gentleman called Stephen Gardner in Raleigh. When we asked Stephen, well, what did you do to investigate as the rationale? Well, we got in discovery this document that shows the extent of the investigation, and that was to merely call the Attorney General's office, which was done on May 10th. When I asked him in his deposition, so tell me, what did they say is the rationale? I asked, is a national forest a national park? He couldn't remember what they said. So I drilled down deeper. I said, well, what is your opinion? He happened to be the Rule 30b-6 witness for the department. What is your opinion? And he repeatedly said, I do think a national forest is a national park. So that was his position. Later, when we appealed to the Secretary of Transportation and asked him that very question, he admitted, and he was very transparent, he admitted that a national forest is not one of the 4 things listed in the statute. So he said it's not a national park. Now, we didn't just say, Google it, look at the list we gave you. We provided volumes of information, including experts, because it was so vague what their position was. When one witness says, I think it's a national park, and then ultimately you have the secretary saying, no, it's not, but we had experts present information to show clearly a national forest is not a national park. There's different reasons why it's set up. Different agencies monitor it. Besides the fact that it's called something else, there's completely different reasons and different agencies and different purposes. They're not the same.
So let me ask you this, because we're not debating whether they get the permit, right? That's not before us.
We're not debating.
So my question for you is it then our decision, like, just how right you were? I mean, is this a degree of how right you were, or if it were a closer call, would damages not at all be in play? Just I'm trying to get a sense of why we're going so deep into this.
Yes. I believe this case does present one of first impression in this state as to damages. Because there are two sources that we're seeking damages. One is the Constitution. The other is NCGS 136, 113, the inverse condemnation statute. So when you look at it from a constitutional standpoint, as we briefed, we believe that when the government acts arbitrarily to deny someone their property rights or interest, that the Constitution is triggered, in that act of depriving someone of their property interest, depriving being denying them in the use and enjoyment of the property. If they do that through the arbitrary exercise of police power, the damages should be a remedy. But there's a totality of circumstances that you have to look at. There's not one thing, because generally you're not going to find some official with a smoking gun and a memo that says, this is how we act arbitrarily. You have to look at a myriad of factors, Judge Collins, and we set them out in the brief. One thing we say is, well, is the law plain? Is it clear? Are they exercising what's called a ministerial act, responsibility, or is there discretion? And in this case, we've set out the law that says this was a ministerial act. There are objective standards that list 4 things, and they just completely, blatantly disregard it. So is the law clear? Is it a ministerial act? Both things, those things weigh in our favor. We also say, well, what did they do to investigate? Well, each one says we did nothing to investigate your assertions other than to call the Attorney General's office so they could set policy. These are their words in the deposition. So the Attorney General's office can set policy. Well, we all know if we took government in 8th grade or watched Schoolhouse Rock, the Attorney General's office doesn't set policy. Policy is set by a General Assembly, and at the end of the day, they couldn't say that this statute is ambiguous. The court obviously found that it wasn't. And so at the end of the day, what investigations did they do? They called up their attorney to get a sort of, give me some backing. But they did nothing else.
Do you have for this arbitrary and capricious act standard, my recollection is in the land use zoning planning context, there's a specific statute that points to awards of attorney's fees, damages potentially for arbitrary and capricious acts. Is there a statutory hook for that component separate from your inverse condemnation? It's purely constitutional.
State agencies. No, there is 160D 1403.1 that provides damages, but not to states. And that's why there's not, if you believe 136, 111 doesn't apply, then the Constitution is what we follow.
But don't these quorum claims kind of come in where there is no other remedy to achieve the right, and here the right is the ultimate issuance of the permit, and there was an administrative process and ultimately judicial review that led to the issuance of these permits?
So the constitutional violation is when the government actors were wearing the cloak of state authority, right? And that's the only way, quorum tells you that's the only way you're going to have encroachments by the state is through the individual actors cloaked with authority. So these individuals are cloaked with authority. And ultimately, they take a plain law, they do no investigation, they cite to no law that justifies the various positions, which I'm going to talk about in a second. They ignore the volumes of evidence. And ultimately, I believe the trial court found that they acted arbitrarily because in issuing the permit, one of our bases was based on arbitrary and capricious grounds. And we believe the trial court agreed with that. But we believe that the government did act arbitrarily here. We believe that the violation is the constitutional violation, right? Issuing the permits, the trial court ultimately decided that on statutory grounds. That just means the bleeding stopped. The constitutional violation has already happened, meaning we were deprived. My client was deprived. The only remedy for the past wrong, the actual deprivation, is not the issuance of the permits. That just stopped the bleeding. But for the past, the actual deprivation, the remedy has to be compensation, because in looking at Article 1, Section 19, historically, going all the way back to early cases, State v. Glenn, Johnson v. Rankin, Article 119, if there's a violation of that, it calls for compensation. So Judge Hampson, just issuing the permits doesn't remedy the past deprivation. If we said issuing the permits was good enough, then the Constitution is rendered a toothless document, because it's not the court decided the statutory grounds get your permit. We were already entitled to the permit. There was no discretion to deny it. We were entitled to it. So the temporary period of deprivation, and this court has held that temporary takings is compensable. The only way to remedy us is through compensation. The Nick versus Township of Scott case, which is a U.S. Supreme Court opinion, there's a good discussion in there about the very question you ask about, well, isn't invalidation enough or injunction to get the permit? And the court says no, because the constitutional violation was that deprivation. Just issuing the permit is stopping it from continuing, but it doesn't address the actual deprivation. And also, as one of the cases we've provided the memorandum of authorities, the Owen case, U.S. Supreme Court again, there needs to be some deterrent element here, Judge Hampson, because if it's just, well, you got your permits, what is that signal to the government of, well, they were always entitled to it, finally they got it? How does that stop them from, in the future, having any deterrence of doing it again? And I would say compensation provides that deterrent element.
There's also the attorney fee issue. So, you know, and under the 6-19.1, which seems to be the statute that the judge was looking at and saying that both parties were prevailing, wouldn't that, if in fact a court awarded attorney's fees, finding that the agency acted without substantial justification, wouldn't that be sort of the remedy that there might be for the initial denial of the permit, that the state then has to pay attorney's fees for that?
So the 6-19.1, which is a legislative remedy for attorney's fees, as we all know, the Constitution here, Article 1, Section 19, Article 1, Section 1, they're self-executing. So it's not up to the legislature. The legislature certainly can't impair the remedy that the Constitution tells us. Paying us back for the attorney's fees is certainly getting us back to a playing field that is equal, because we all know that when we fight the government, they're using your money, they're using their money to fund the litigation, and it's just a question of attrition. So at the end of the day, when the state repeatedly in their brief says, just move on, that is what they're trying to get you to do, is just move on. But the end result of the loss to the value of the property, which Harry Newstreet in the record is an appraiser who applied the test of diminution in value that the Finch court accepted, that is very similar to what Maida recently said, said there is a harm to the property owner in terms of the property rights were diminished by X. Attorney's fees are not touching that wrong. So what I would say to you is 6-19.1 is a signal from the legislature that we need to keep the playing field level, but it's still not solving or remedying the actual constitutional violation. And the only way to do that, again, is through compensation addressing that wrong. Which again, there's no evidence in the record from the department where they rebut any of that. Actually, if you look at any of the briefs or arguments, they don't even talk about methodology, how you determine damages. They didn't even get into rebutting attorney's fees and expenses. The trial court just made this ruling from out of the air with no arguments from the other side. It would be very helpful to get attorney's fees in this. But again, it doesn't. It's not the remedy for the constitutional violation. So, as I mentioned before, quorum, we believe, sets the foundation for what we're asking. Again, I'm saying this is a very important decision because we do not have one directly on point. We do have a couple decisions from the Court of Appeals that have addressed the implementation or administration of law. The Eastern case, the Weeks case we've cited, both of those found that the governmental actors were acting within the scope of their authority. They then moved on to how impactful were the decisions, which are the two parts of the ends means test. So we don't have a case that it says, well, what happens if there's an improper exercise of police power authority? You know, Kirby talks about that as being part of the test for whether there's a taking in North Carolina, but we don't have yet an opinion that addresses that. That's this opinion. Ultimately, as we've set out in the brief, there is a fundamental right here in North Carolina to use property, to follow a lawful calling, and the government certainly can restrict and regulate those activities. These are not nuisances that are occurring where people do not have rights and to do things like sell alcoholic beverages has been deemed to be an activity that can be heavily restricted, if not prohibited, because of its nuisance quality. Outdoor advertising is not that. And at the end of the day, based on the Stanton versus Railroad case and the Knight versus Albemarle Railroad case, we had a deprivation. Deprivation, when you have a lawful calling or a lawful purpose for the use of property, deprivation is interrupting free use and enjoyment of that. The exception is, of course, if you interrupt it in accordance with the laws of the land, or the law of the land, then you're allowed to interrupt it, right? Well, the department didn't follow the law of the land. The law of the land is this controlling statute.
So I want to ask, is the agency entitled to deference under our existing laws of the statute?
Well, of course, the U.S. Supreme Court recently gutted the concept of deference, but deference is not in the face of a clear law, even though your deference opinions have always said, but if the law is clear, we don't give you deference. You're not construing something. You're not exercising discretion when there's ambiguity. So we're not going to give you great consideration. And by the way, Judge Collins, there are different opinions from this court as well as the Supreme Court that really denotes there shouldn't be even deference. But in the cases of the Court of Appeals that cites deference, it's only when the law is unclear. So that's a red herring to say, defer to me the ability to rewrite the statute. When it's clear, I would say there is no deference in that instance.
But it's not an uncommon process that a permit is denied. It goes through the judicial review process, and it's overturned. The permit should be issued because the department made a mistake in interpreting either the regulations and or the controlling statute, right? So what are the guardrails here if we're looking at this as a damages claim to, so we're not put in the slippery slope position that anytime a government agency denies a permit, they are automatically at risk for compensatory damages?
So there's no automatic to just, I acted to deny something. That is not an automatic right. Again, that's why you got to go through the totality of these factors I'm telling you about, because I'm not touting that if they make a simple mistake, that drives our Constitution. Because I would agree that Article 3 assigns responsibility of execution to the executive branch. And inherent of that, they are supposed to execute. But the great thing about Article 3 is it doesn't override the authority of the General Assembly to make the law. They're not supposed to make law in execution. The folks here at the department made law. They were trying to overturn what was clear because they felt like something was too pretty to have a billboard next to it. And so it's not a simple mistake. As we laid out in the brief, there's a multitude of things you have to look at. One of which I didn't get to in talking about the question of Judge Collins, is at the end of the day, what law did they cite to? And the rule of law is so critical in this case. What did they cite to that says, oh shucks, we were reasonable, we were acting in good faith? What law did they cite to justify their position? Well, ultimately they said, well, we get to look at this paragraph right here, the purpose section. The Secretary of Transportation said, I can add an infinite number of things. These are his words. He agreed that if he can look at this and he could add an infinite number of locations to be protected, simply if he follows the purpose. At the end of the day, what law do they cite that says purpose sections can override clear standards? There is no law. All the laws to the contrary. And guess what? A purpose section is not a law or regulation. Purpose section sort of motivates what the law would be. The General Assembly was motivated by all these things and then set the standards in 1 and 2. Right? So there is no law that supports their positions. So not only all the things I've said before about there was no investigation other than calling up their attorney, they ignored all the volumes of evidence. They ultimately, and by the way, they've cited to multiple, after the Secretary ruled, they've cited to multiple statutes. There's another statute that, again, after the Secretary's ruling, because they cite to this statute, 136-127, in their brief. I think it's a sign of arbitrariness to cite to a statute the Secretary clearly said he wasn't relying on. But again, look at the slippery slope. I'm glad you used the word slippery slope. Look at the slippery slope if the department could simply, through implementation of pulling out of their brain what they think is pretty or beautiful, the Secretary said, well, what's recreational is if you can get out of a car with your dog, that's sufficiently recreational so that wherever you are getting out with your dog, I can tell you, you can't have a billboard there. A church is sufficiently pretty, so you can't have billboards near churches. He ultimately said, I am making infinite what the statute provides is finite. He admitted that. Because, again, they're pulling from purpose sections about all these things.
Let me just warn you, you're within your rebuttal time. Sorry.
And I would just say that if they wanted to protect a corridor, they have a scenic byway option, or they could make regulation and go through the process of debate and public involvement to create law. They cite to no regulation defending their position, and ultimately they use a purpose section to rewrite the law. And this is a slippery slope that if a governmental agency can usurp what the General Assembly does, we're in a lot of trouble. It's the whole point of forming government, is to have these branches the way they're set up. Thank you.
Good afternoon, Your Honors, and may it please the Court. My name is Jessica Price. I'm here on behalf of the North Carolina Department of Transportation, and my co-counsel here is Miranda Holly. Your Honors, this case is actually fairly straightforward. We're not contesting the issuance of the permits. The trial court said that we were outside the bounds of the interpretation of the statute at the time, and therefore we issued the permits. The argument at issue today is, according to Gray, is that they are entitled to the permit to build or construct an outdoor advertising. And the courts have said, a permit grants a privilege. It does not create a fundamental property interest, nor does the right to construct a billboard equal to a constitutional or fundamental property interest. However, according to Gray, they are entitled to damages under North Carolina General Statute 136-119, 6-19.1, 6-21.5, 6-20, and 7A305D, as well as Rule 11 and 37C sanctions for a taking. Specifically, Gray is arguing that because NCDOT denied the 4 permits in regards to the single-purpose leasehold in which they had obtained, which was the single purpose was to construct a billboard, that equates to a taking. And that is not what the North Carolina Supreme Courts have held, and that is not what the Court of Appeals have held. The North Carolina Supreme Court held in Hersey v. Gibson that a permit is a privilege. A liquor license granted a privilege. It did not convey either a constitutional right or a property right in regards to the selling of alcohol, beer, and why.
So I want to go back to the other side's point of if you can deny a permit for a privilege and just keep denying it and denying it, denying it, what are the guardrails for that? What's going to stop you from, even if we were just to assume that it was arbitrary denial, what's going to stop you from doing that without damages?
Your Honor, NCDOT does not see the denial of this particular permit. They looked at the declaration of the policy and they looked at the items listed that was in 136-129.2. And based on the declaration of policy, which the legislative branch gave NCDOT the regulatory authority to regulate where and how the construction of billboards took place. They said, in order to preserve and enhance the natural and scenic beauty of the highways throughout the state of North Carolina, we have the ability to regulate those signs. The interesting part is the fact that when we received the application for the permits within 1,200 feet of the National Forest, we did not see it as an unreasonable, arbitrary idea that we would extend the protections that are for national parks, state parks, scenic wildlife and refuge, and things of that nature.
Well, let me just ask you, it's more of a hypothetical than exactly what here. If it were an completely arbitrary denial of a permit, are damages allowed in that case?
Your Honor, that would be an issue for the trial court to determine if they felt that we were being arbitrary and capricious. But given the circumstances of the declaration of the policy and the specific fact that NCDOT was provided with the regulatory authority to determine where billboards would be placed.
So I guess I'm asking you is, do we have to determine here whether it's arbitrary? Because if it is arbitrary, then damages are allowed? Or are damages never allowed even if it's arbitrary? Is there some other means?
In this particular case, Your Honor, we do not believe that damages are appropriate because that's not the issue in regards to being arbitrary and capricious. The issue in this particular case is that Grey is arguing that they have a fundamental property right, a constitutionally protected property right in the issuance of a permit to construct a billboard on a piece of property in which they don't even own. They entered into a single-purpose leasehold, which was conditional on obtaining permits. They themselves included a clause in their lease.
Well, a leasehold is a property right.
Yes, Your Honor.
That's established.
Yes.
And I would imagine that every contract or every lease that an outdoor advertising company enters probably has a provision that if we can't get a permit for it, then we have a right to cancel it. I mean, that would make sense.
Yes, Your Honor.
But obviously, the whole idea is that they're going to use it for outdoor advertising.
Right.
That's their business. That's why they're doing this. So, so I understand your argument, and it might go more to the inverse condemnation angle of things than to a constitutional violation. But I think what we're asking about is, let's say that assume it's a completely arbitrary denial. Okay, let's just assume that instead of maybe, we've got this, pretty clear statute and whatever, but let's just say that the secretary said, I do not like Bob who asked for this. It's denied. It's just purely arbitrary. Is there no world in which damages could?
In that particular instance, Your Honor, I believe actually damages would probably be appropriate if it was just simply, I don't like my neighbor who wants to put up a billboard, therefore I'm going to deny it. That wasn't the case here.
Right, I understand.
Yes.
But yeah, that's what we're trying to figure out.
Yes,
Is there something so arbitrary that might be? So then, of course, we have to figure out how do we know what is so arbitrary? If the trial court has determined that the statute is clear, I'd say that was correct, and DOT did not appeal that ruling. So for our purposes, that statute is clear and unambiguous.
We feel in this instance, at the time of the denial, it was not an arbitrary and capricious reason that we put forth. The declaration of the policy in regards to the statute states that in order to enhance and promote the natural and scenic beauty of the state highways within North Carolina, and then they proceed to list multiple ways in which we are able to deny permits. We at the time did not see it to be completely unreasonable or unfathomable that a national forest where you can camp, hike, bike, and fish, and things of that nature, which are similar to that of a national and state park, and the other items listed. We did not see it as an unreasonable interpretation to seek an extension and or modification of the law to include a national forest in this particular instance.
So is that, just drilling down, is that the argument, is that a national forest was a national park? Ultimately, is that what the permit was denied for?
We were not arguing that it was a national park. We were arguing that it provides the same type of scenic and recreational value as the items listed in the statute 136-129.2. And they are similar in nature, and therefore we did not see that it would be so outlandish to include the national forest in the protection of those items listed. And Your Honors, in continuing with this idea that a permit is an entitlement, that they are entitled to a permit, the North Carolina Supreme Court again said in DOT v. Adams, they affirmed Hersey in the fact that a permit grants a privilege. It does not convey either a constitutional right or a property right. They also further stated that billboards in and of themselves are considered personal property and or trade fixtures.
Well, that was if I'm not mistaken, wasn't that the case where the lease had already expired on the land? And it was just a matter of the owner of the billboard still owned the structure, but they actually had no leasehold interest.
In that case, Your Honor, actually that was a condemnation case in which a widening project was taking place. Okay. And so therefore NCDOT purchased the property on which the billboard sat. Okay. So it was a valuation of determining what the value of that leasehold interest was in relation to the billboard being constructed on top of it. And so they were seeking how much compensation should they receive based on that. Further, Your Honor, in Hillsborough v. Smith, the Supreme Court, again, the North Carolina Supreme Court affirmed a permit does not in itself confer upon a defendant a vested property right of which they cannot be deprived of by a zoning ordinance. In this particular instance, an individual who had already obtained a permit had the option to buy a lot next to their already existing property in which they owned.
Right, and I think we're clear on, I mean, obviously you don't necessarily have a right to a permit. However, in this case, they did have a right to the permit. That's kind of the problem, right? Turns out under the statute, they did have a right to the permit. And they didn't get it.
In this particular case, the trial court determined that we had reached outside the scope of the statute, yes, Your Honor. However, that doesn't mean that the permit itself creates an entitlement or a constitutionally protected or fundamental right. If we look at a permit or the right to build a billboard simply based on that permit, you're basically taking away the regulatory authority of the NCDOT to a perfunctory manner.
Well, how is it taking away the authority? I mean, certainly assuming that that they comply with whatever conditions the permit gives, then they have a right to do it. Obviously, if they were to do something not within the permit, DOT still has a right to regulate that.
Well, it goes back to Judge Hampson's argument earlier in the sense that if this is going to be the case in regards to interpreting whether or not a person is entitled to a permit, then basically what we're saying is anytime a denial occurs, then they automatically have the right to just compensation right off the top because it's a fundamentally protected property right.
I don't think that's the case. I think we'll have to determine whether it was outside of the scope and an arbitrary taking, right? Isn't that what we're trying to figure out? It's not just that it was denied, but sort of how and why it was denied.
And again, Your Honor, we argue again today that it was not arbitrary or capricious or unreasonable to, in regards to the interpretation and application of NCDOT's law at the time, that a national forest, which again provides similar in nature the items listed that are prohibited in 136-129.2. We do not see it as unreasonable or unfathomable that one could simply look at a national forest and what it has to offer and how that would be the complete opposite of a national park or a state park and the same items that are listed.
Is there any use for this property other than to construct a billboard?
No, Your Honor. Not that I'm aware of. Excuse me, not that I'm aware of. According to the pictures that we received in regards to the location, it looks like a fairly large lot, but I'm not exactly sure of the zoning ordinance surrounding that area and what that area can be also used for. But outside of the leasehold interest, the property owner herself, I'm assuming, could do anything that she saw fit in regards to her ownership of that property, including signing a lease over to someone, or sell it or develop it and things of that nature. Because, and it's interesting that you bring that up, Your Honor, because the comparison between the case here at hand and Kirby, that was a case in which the MAP Act was deemed unconstitutional because it was a complete taking of the fundamental property right of the owners in that. Individuals who actually own the property were completely divested of their interest because they were not allowed to develop it, sell it, split it, or anything of that nature. They could not do anything for an indefinite period of time. That is not the case here. The case here is that this was a single-purpose leasehold, and they're trying to create a constitutional fundamental right to a permit to construct a billboard. And that is, both the Supreme Court and the Court of Appeals here in North Carolina have said the right to a permit is a privilege, and the right to construct a billboard is not a fundamental property right.
Right, but like I said, again, I don't think they're not saying they have they're just saying they have a right to expect that DOT is going to follow the statute and give a permit under the circumstances that it should be granted. And it's not going to be arbitrarily denied.
And again, Your Honor, we issued the permits, and we are not contesting the issue of those permits. The trial court told us we were wrong. We were fine with that. We issued the permits, and now basically what Grey is seeking is to punish NCDOT for that original denial. Again, we were not being arbitrary and capricious in our interpretation and application of the statute. We simply looked at the statute and the declaration of the policy and determined that it would be reasonable to include the national forest in the items that were listed. The trial court told us we were wrong. We issued the permits, and now Grey is seeking to punish NCDOT for that denial.
Well,
Go ahead.
I was going to say, there's two theories of compensation, right? One is the constitutional claim, which is sort of grounded on an arbitrary, capricious act, allegedly, of NCDOT in denying the permits. That's sort of one piece. That's the arbitrary, capricious piece.
Yes, sir.
The second piece is the inverse condemnation, right? Essentially, has there been a taking? Which a taking is a taking, and carries with it the right to compensation. And so I think I feel like we've kind of been blurring the lines between the two theories of compensation here. So you kind of made your argument that it wasn't arbitrary and capricious, or at least there's no genuine issue of fact, as Judge Tessner found. But on the other hand, focusing on the taking, I mean, that's where this question of whether there was in fact any property right that was taken comes into play. Is that correct? Am I kind of
Yes,
understanding the waterfront correctly there?
Yes, and to address the taking aspect of it, the Court of Appeals has addressed that in Adams Outdoor Advertising v. NCDOT. In that particular situation, Adams owned 11 billboards and they actually owned the property in which they sat. And NCDOT planted vegetation and trees that would eventually block the view. Adams argued in their case that basically NCDOT, because they were blocking the visual aspect of the billboard, which its sole purpose is for people to see it, they basically rendered those billboards economically useless and therefore equated to a taking. And the Court of Appeals said that there is no such right to be seen, and it was not a taking and therefore was not compensable. And because I'll quote it, excuse me, so I don't bungle it. A substantial interference with the elemental rights growing out of the ownership of the property. So there's no such right to be seen, and so therefore they did not find a taking in that particular situation, where 11 billboards were blocked by NCDOT's planting of the vegetation.
But that was because DOT was doing its proper role of managing the right-of-way and the vegetation within the law.
Yes, Your Honor. And again, to go back in regards to the idea of the law in and of itself, we, again, do not believe that it would be arbitrary and capricious to seek a good faith argument for an extension or modification in the law based on the declaration of the policy and NCDOT's regulatory authority to determine where and how billboards are placed.
So this case was decided at summary judgment, effectively.
Yes, Your Honor.
Which would suggest there were no issues of genuine issues of fact to be decided. And I guess one question I have now as we talk about was this arbitrary and capricious act is, are there factual disputes? Are there credibility issues that we need to send this back to be addressed? Was summary judgment just premature?
I don't believe so, Your Honor. NCDOT does not believe so. The simple fact is we've issued the permits. We were told that we were outside the scope in particular interpretation of the law, And the judge also reasoned that they were not entitled to just compensation and attorney's fees and costs of that nature based on the arguments that we made in our memorandum of support of that motion for summary judgment. So both parties are prevailing. Gray received their outdoor advertising signs.
Well, let me,
Or excuse me.
the thing about both parties prevailing, I have a question on that. So that language, of course, comes from the 6-19.1. Okay, so, and, you know, we have, the plaintiff has several, really three, 2.5-ish claims, okay? We have the denial of the permit with the constitutional issues in it, and then we have the inverse condemnation. So didn't the plaintiff actually prevail on the permit claim? Like on the administrative review, you know, the permit issuance, the plaintiff prevailed.
Yes, sir.
They got the permit.
Yes.
The claim could have just been that. So I'm a little confused about the trial court saying that both parties prevailed, because on the issuance of the permit claim, it would seem to me that the plaintiff clearly prevailed. The defendant lost. There were some other claims that, you know, that the plaintiff did not prevail on, as far as damages or whatever. But I was kind of trying to figure out how the trial court crammed all of them into that statement.
The attorney's fees that Gray is requesting in regards to 136-119 and 6-19.1, all of those are basically in regards, we know that they're abuse of discretion, but in regards to whether or not the trial court decides.
Well, go ahead.
Oh, sorry. In regards to whether or not the trial court decided to award attorney's fees, the statutes in and of themselves say that they will provide the attorney's fees unless the agency, based on their decision, did not make that decision without any kind of sort of substantial justification. So clearly the trial court felt that in regards to the argument that we made in regards to our interpretation and application of the statute, while they disagreed with our interpretation, did not view it as substantially unjustified, or they did not view it in bad faith. Because again, we did not deny Gray the permits out of bad faith or anything, or with malicious intent or anything of that nature. There are over 80,000 miles of state highway and streets within the state of North Carolina. We did not tell Gray that they are not allowed to build, we did not tell Gray that they were not allowed to have a permit or that they were not allowed to build construct a billboard. We simply requested that this area probably isn't the most appropriate according to our interpretation of the statute at time.
Right. So, but like on the attorney's fees, so under, you said in the court's discretion. Now, if it's under the 136-119, it's actually mandatory. If the court were to find that the plaintiff is entitled to compensation, in an inverse claim, the fees are a shall, not a may.
Yes.
Whereas in the 6-19.1, they're a may. They're
Yes.
a discretionary.
And the only time it would be a shall is if they find that they are manifestly unsupported by reason.
Right.
And again, the trial court obviously found that our argument, while was reasonable and it was substantially justified, it did not reach to the level of that good faith argument in the extension and or modification of the law, which is why they issued the permits, but they denied the attorney's fees and costs under the statutes in which Gray provided them under. And I will say, and lastly, in regards to the argument as far as 7A-305D is concerned, that is another statute in which the courts have said that it is mandatory, but in order to get to that mandatory, they have to go through 6-20, which again is discretionary. So 6-19.1, 6-21.5, and 6-20 are all may. And so therefore, if the trial court determines that we made a good faith argument, that we were not without substantial justification in the reason for our denial of the permit, then they may choose to not award those attorney's fees. And that's exactly what the trial court did. They decided that while we were outside the scope of the statute, we were not so unreasonable or arbitrary or capricious that Gray was entitled to those attorney's fees and costs in which they requested. Therefore, they denied those fees. And in regards to Rule 37C and the Rule 11 sanctions, again, those are good faith, based on good faith arguments and reasonable grounds. Again, NCDOT did not pick up the application and go, nope, we don't like Gray Outdoor, we're denying it. They looked at the statute, they looked at the declaration of the policy and the purpose of the statute, which was to enhance and protect the natural and scenic beauty of the state highway system within the state of North Carolina. Therefore, they denied the permits. Again, we did not say that they could not build or construct a billboard. We just simply requested that they seek a different location. There are over, I believe, 80,000 miles, and again, we have no issue with permits. There are over 8,300 permits that we have issued. We have no problem with billboards. It is just simply up to NCDOT to regulate the placement of those billboards, and they did not think that the chosen location in which Grey had chosen was proper. In summary, Your Honor, unless either one of you have a question, I would. Okay. In summary, Your Honors, there is no constitutional right or fundamental property right to a permit for the construction of a billboard. NCDOT never told them they couldn't have it, period. They also simply gave them multiple locations in which they could pick a different spot. And so, therefore, when the trial court denied attorney's fees and costs, it was not for the reason that Grey would have you believe that we were out to get Grey, or we were out to get, or from a malicious intent denying of the permits, to be arbitrary and capricious. And so therefore, Your Honors, we just simply request that you affirm the trial court's decision in denying the award of attorney's fees and costs. Thank you.
The trial court's ruling on attorney's fees and costs had a singular rationale. Both were prevailing parties. This idea about good faith, reasonableness, there's nothing in the trial court's order that would suggest the trial court was deciding they were reasonable. There was substantial justification, just as both were prevailing parties. The question of arbitrary and capriciousness is a question of law. As long as the facts are undisputed, that question is a question of law. Transatlantic, or Continental, we've cited in the memorandum of additional authorities, as well as the Barger versus Smith case that we cited in the brief, stand for the proposition it's a question of law, arbitrary and capriciousness. This idea that a permit stands between you and a right is disturbing. The right to use property in North Carolina is a right that existed before our Constitution. We cite the Material State versus Advent case. There's Latin words used that the right existed before the Constitution, the right to use property. It's not dependent upon a permit. It's true that the government can regulate. The government regulates through known laws. The DOT wasn't regulating here. By their own words today, they said we were extending and modifying the law because we thought it was appropriate. That's not regulating. Regulating is creating regulation that is known or following a statute that is known. Simply just saying something's too pretty, the General Assembly must have meant for us to give this authority to extend it, is not law.
Can you just speak for a moment on, are the damages speculative here that you're asking for?
So we provide evidence following the rationale for damages set out in the Finch case, footnote number 1, that talks about fair rental value, that talks about diminution of property value. So we submit affidavits from experts as to those things. The DOT never rebutted that information, never argued against that information. So I believe that on summary judgment, we provided the only evidence in the record that actually followed the methodologies that either this court or the Supreme Court has said are available when you deal with a temporary take. So going Adams versus DOT, Judge Stroud, that was did the DOT have a right to plant vegetation in its own right-of-way? Sure. That case has no really merit in here. But going back to the idea that the right to erect a billboard is not constitutionally protective if the laws are followed and they're entitled to the permit is so disturbing. This is not necessarily a billboard case, folks. This is about fundamental property rights. And when the government basically says, I'm disregarding the law because I don't like it or I think it needs to be extended, there's pathways for them to do that. Not through implementation and administration from a cubicle, but by regulating through creating regulation. If they don't do that, if they don't designate it scenic byway, which they have the path to do, They can't just extend or modify. How dangerous of a principle that is. So this case, this idea to move on, you got 8,000 places you could put it. We have a leasehold interest. It's a property right. We have a right under our lease to control the possession and use of that property. At the end of the day, if we meet the standards, we had a right to get the permit. This right is a fundamental one that existed before the Constitution, and it's what the Constitution is meant to protect. Again, this is not a billboard case. We interface with government all the time. When they act arbitrarily, where should be the source of the remedy? And in this case, the constitutional violation is not remedied by simply issuing the permits. Because guess what? They would just say, oh, so bad, we'll see you next time. Well, next time, there should be clear direction that this court says, look, if you act arbitrarily, you're going to have to compensate. And there's evidence of the record, again, about the methodology about damages, Judge Collins. So, Your Honor, we respectfully request that the trial court be reversed as to the summary judgment ruling denying damages. We ask that there be a remand for the court's reassessment of attorney's fees and costs based on misapprehension of the application of legal principles. And thank you very much for your time today.
Thank you all very much for your arguments. And we will recess.